I have sometimes wondered whether the Supreme Court should be asked to determine whether the Constitution on its face, looking at it on its face, is wrong. Because at 45.2, I haven't answered your question, I know, but I'm just laying the ground.
Yes.
45.2 says every adult has the right to marry a person of the opposite sex. Now, what happens to the transgender and intersex people in Kenya whose existence we have acknowledged? Have they in effect been excluded by the Constitution? And probably more pointedly, and I think now this comes to the question you're asking me, is if two intersex or two transgender people come and say they want to marry, and the courts have determined that they are entitled to rights, are they then to be denied the right to marry using Article 45.2? And could it be that the drafters of the Constitution then were mistaken in the wording they have used in 2 because they have in effect discriminated? And further still, whether then the Constitution on its face is wrong and discriminatory. Now, to the question you've asked whether what I would do if I had two same-sex individuals seeking permission to get married to each other. To the extent to which there exists that clause 45.2 saying the limit of people who can marry each other of opposite sex, I would say it is not possible. However, Commissioner, it is an issue I've looked at because I had, in my previous life, I had been asked to consider an argument on this. I have sometimes wondered, Commissioners, whether Article 45 can be read to represent two scenarios. The first scenario is that one limited only to paragraph 45.2, being two adults needing to marry, in contradistinction from a situation where the heading of that Article 45 is headed family. And then one says family is the natural and fundamental unit of society. Whether it is possible to deny permission for marriage, but the Constitution inherently acknowledges that you can have a family of same sex. That would be my contention, that for purposes of marriage, probably as a judge, I would say the law is clearly prohibitive. But then I would wonder then whether the law seemingly at clause 40, so the only exclusion is 45.2. 45.1, 1 and 3 and 4 seem to accommodate existence of a family. And so if it is possible to argue that there is a difference between a marriage and a family, then it should be possible also to say that there is almost a permissive extent to which the Constitution allows a family constituted of people of same gender. Of course, I'm very much alive that I am a candidate. I know it's a very unpopular argument, but I'm just making it as a legal argument. I'm not making it as a question of my position. I need to clarify that. The second limb of your question was whether then you could say that Article 16 of the Convention on Women's Rights, I am not very familiar with that convention, whether that Article 16 is one of those unenumerated rights. I think the Article 19 that you had invited me to was very explicit that they are tenable to the extent to which they are not inconsistent with the Constitution. So if the question was whether or not they can get married, I would say it is not one of those rights that are protected. But if the argument is that we want to be recognized as a family, then I think the matrix of the issue would be completely different. Probably then there would be an argument around it, Commissioner.
Okay.
The question was very long. I have tried as much as possible to answer it. I don't know if I've answered it.
Yes. So